Hey, good afternoon, everybody. RREAF Academy, Season 3, Volume 3 today, right? We're on Week 3. I'm David Cragle. I'm General Counsel here at RREAF Holdings, and proud to be an opportunity, really, for me every time to get in front of you guys and be able to chat with you about a subject matter that has some importance to me, or I think to you probably. So today, somebody else was going to be here today, but Brad asked me early in the week to see if I could step in. And I said, there's a subject matter that hasn't been in our course sets in the first 2 years that I probably should have addressed in year one. It's so fundamental, and that is what I would refer to and what we refer to in a law school sort of setting, or even in an undergraduate setting in a business program, as business organizations. Right? So let's just talk about business organizations today. Short, we call them biz orgs. Let's talk about business organizations and the kind of entities or contractual arrangements we can use in business generally. And I'm going to give you a quick general overview of them, and we'll talk about definitions kind of and how we think about them. And then we'll go down through a chart that has some characteristics and some notes I've made across various categories of these things. And there's a whole lot of detail. As I suggested to somebody earlier in the week, I could probably extemporaneously stand up here and talk for 6 hours about business organizations. We don't want to do that. We're going to talk for an hour today, and we're going to put some flesh on this outline and hopefully give you guys a sense of not only what business organizations are available for us to use in the conduct of business today, but the kinds of things we look for in real estate applications in particular, since that's part of what we do here. All right. So let's run down through it quickly. Let's start with that first handout that was on top, the definitions, the business enterprise definitions. It's important for you to understand sort of the width of, or the field of, possible organizations that we could use. And by the way, these are only the primary 5 or so that you'll find out there in business today. There are some other sort of specialized entities we could talk about using also. I'll mention a couple of them, but we won't get into them. So you could have a sole proprietorship. And a sole proprietorship is simply a business that's owned by a sole party, a single party, and the conduct of that business is either an operation of a business or an investment. It could be a sole proprietorship simply to hold a piece of real estate for profit purposes. They're always for profit purposes. So this is a sole party that owns the business and runs it. So you might think of the guy that has the hot dog stand over there. All right, he has a business. He runs it for a profit, and he owns all of it. Presumably, right? Presumptively, as far as we know, right? The guy at the shoe shine stand in the airport that you walk through, and I'd invariably stop and get my shoe shine because I was headed to a meeting. That guy's probably a sole proprietor. He probably hasn't bothered to incorporate. He owns that business, and he does that for profit, and he gets that profit out of the fees that he gets for the services he provides. Okay? Unincorporated organization that's owned by a single owner, sole proprietorship. Comes out of old English common law. Partnership. So what's a partnership? Well, we all know sort of inherent in the word, at least in English parlance today, that it means at least 2 people, right? 2 or more persons. In this context, in the business context, it means 2 or more persons who are gathered together, who have joined themselves economically for the purposes of an undertaking for profit, to share with an intent to share profits. That definition is used not only generically in the courts, but also, for example, in the Internal Revenue Code and regulations where we talk about the profit's purpose. So it's not merely enough that we get together on common purpose. It needs to be a business undertaking with the intent of making a profit and sharing profits between each other in order for us to have a partnership with partners for federal tax purposes. And we could get into the tax side of things. That's an entirely different topical area We'll talk a little bit about tax today, but there are some nuances or differences when we talk about these definitions. There are some nuances in the tax area that may not be the same. It may not be defined exactly the same in a court of law, for example, where tax is not at issue. Okay? So just understand, sometimes there's some distinctions there that are separate and apart. The tax code is driven with specific purposes and for specific reasons with particular aims, and therefore definitions sometimes change. And we've got to live by those definitions if what we're doing is arguing over a tax matter. If we're arguing over a legal matter on the formation of an entity, we wouldn't be using those definitions. We'd be using the definitions applicable over on the law side, right? So anyway, partnership. Joint venture. All right, so joint venture, you hear that a lot, right, in business. Okay, this is a JV. You'll hear that, especially it gets thrown around this shop a lot. All right, we talk about, oh yeah, that's a JV. So a JV undertaking is generally, and by the way, people can misunderstand these sort of definitions or use these terms more broadly or without precision. I'm going to be precise in the way we define our stuff today for purposes today. A joint venture is a specific undertaking or project, generally for a specific period of time or with a definitive sort of ending intended, whether we know that time or not. For example, sale of the project would be the end of the project, the end of the venture, the joint venture. Undertaken by two parties, ordinarily commercial parties, obviously, for a profit's purpose. Starting to sound like a partnership, isn't it? It's because it is. In the old-fashioned definition, a joint venture was merely a subcategory of partnership. It was a partnership for a specific purpose, for a specific undertaking, for a specific period of time, or specific conditions. Partnerships like, for example, in the old days, a law partnership. Let's talk about that. Two lawyers get together and decide to have a partnership together. They have a general partnership. They may have an oral partnership, or they may reduce it to writing. But it's a partnership, and they agree to share profits in a certain way. Is that a joint venture? Specific purpose. It may not be for a specific time period, however. And therefore, if it's open-ended, even though it's being engaged in for the purpose of providing law services, we probably wouldn't call that a JV in the true sense of the word. It's not really a specified project for a specified purpose, even though it has a common end, it has a common aim and a common end and common services that are being rendered. It's simply a business two parties have joined together, partnership, for the intent of, for however long it is, rendering those services into the market, right? So probably not a joint venture, but definitely a partnership, okay? To give you a flavor of how that would work. Two commercial parties getting together. Don't know who's bringing what, right? It doesn't matter who's bringing what. So one party could bring property and contribute property into the partnership. The other party could bring money, contribute it into the partnership for a specific purpose. Good. A specific property for a specific piece of land or development of that land for specific purposes with the intent to make profit off of it and then dispose of it one way or the other, in one form or fashion or the other, whether over time or all in at one time, and be done. That would be a joint venture. Now, in the old days, we would do that as a true general partnership, and we'd have a big partnership agreement in common law. I mean, in the law today, if we did that kind of real estate partnership, and nobody does them anymore, by the way, this way, but we'd have a 50 or 60-page partnership agreement, right? It would be a great, big, huge agreement, and it would lay out every single thing that was going to be required by the parties, their duties, who's responsible for management, and what happened if the whole world blew up, and all those sorts of things. How much money has to be contributed? What happens if we run out of money? All those issues would have to be vetted, worked out, and documented, right? Now, so that's a great example. But we don't do those anymore. And we're going to talk about the other sets of stuff here. But today, corporate, and I'm going to use corporate generally, not necessarily just corporations, but corporate business today when we have specific projects that go into ventures, specified ventures like that, people still refer to them as joint ventures, but they're not partnerships. I haven't seen one. Let me just say this. I haven't seen one in my 33 years of practice. I haven't seen anybody enter into a JV in the old general partnership form. Everybody today uses limited liability companies as the engine, or in the old days, we just used a corporation or we used a limited partnership. We'll get to that. We'll get to why in just a second, but in another couple minutes. But today we no longer use partnerships as a matter of law, and we'll talk about why. Partnerships to house these joint ventures, to put a wrapper around them. We now put what's called a juridical entity, juridical fancy word for created in the law, and a creature of law by statute, that houses that joint undertaking. So instead of using the word joint venture, which is sort of specific to partnership, I'm going to use joint enterprise or undertaking that we house inside of a limited liability company or a corporation or a limited partnership. Okay? So that's joint venture. Corporations. You've got the definition right there in front of you. It's a fancy one. It's an association of individuals created by law or under statute, under authority of law, having a continuous existence independent of the existence of its members, or in that case, shareholders, and powers and liabilities distinct from those of its members. That's the definition of a corporation. You can apply the same definition, but change the words a bit, to limited liability companies. Limited partnerships, slightly different. We'll get into that in a little bit. But you could almost say the same thing with respect to a limited liability company, that it is an association of individuals still that is created by law or under the authority of law, a statute, the limited liability company statute in this case, instead of the corporation law statute, having a continuous existence independent of the existence of its owners or members in that case, and having powers and liabilities distinct from its members. So why do we distinguish that? Why did the law distinguish that definition from, for example, the definition of partners or partnership? Because the law had decided long before that, under English common law, that the association of two parties together outside of a juridical entity or fictitious entity formation, when that wasn't available under statute at all, and two parties got together for business, the only way they got together was in a partnership. Yeah? And partnerships, partners in partnerships, true legal partnerships, are, I'm going to use fancy words, lawyers' words, jointly and severally liable for all debts and obligations of the partnership. Now, my saying that probably hasn't really hit you right there. But when I say joint and several liability of owners, you ought to shudder just a second, and you ought to run as fast as you can from that, okay? One of the things we do in the corporate law is protect our owners, people who are the members, the contributors of the capital and the property to the business, from liability that could occur inside the business. And because of that, routinely, this is why JVs aren't done through partnerships anymore, legal partnerships. They're done inside of a juridical entity by statute, either a corporation or a limited liability company or a limited partnership that exists separate and apart from its owners under law. And the way we do that is we file a charter, and we'll talk about that in a little bit. But we file a certificate of formation, or it's called all kinds of things in different jurisdictions. These days, we're getting close to being kind of unanimous across the states about what that document is that gets filed with the Secretary of State of the state in which you're going to file your charter. A charter is a certificate of incorporation, a certificate of limited liability company, articles of incorporation, articles of formation, certificate of formation. There's lots of different words that are used in the varying state statutes across the country to describe this filing. but it's a single filing that establishes and creates the entity, whether it's a limited partnership or a limited liability company or a corporation. They are all created by the filing of a single document. Sometimes it's multiple pages. In our case, when we file what we call long form certificates of formation generally. So I like to include within our long forms a whole lot of stuff about indemnification and a lot of other fancy things we'll talk about in a few minutes. But I like long form filings. Lots of people out there, and the vast majority of them, don't do long form filings. They do short form filings. And all that's required, for example, in Delaware, if we want to file an LLC or a corporation or a limited partnership for that matter, in the state of Delaware, all that's required is that you list its legal name, that you list its registered agent in the state for what's called service of process. If you get into a lawsuit, somebody's got to serve somebody. If there's a lawsuit, has to be a legal registered agent, and then a signature at the bottom that says authorized person. That's just about all you have to file to start an entity in the state of Delaware. Texas, a bit more than that, not quite that little. But now, if you have a corporation, there's a few more paragraphs that have to go in, even in Delaware, because you have to have what's called capitalization. You have to tell them how many classes of stock you're going to have and how many shares there are going to be and whether it's going to be par value stock or non-par value. There's some other detail, right? But you can do it in a single piece of paper. Single piece of paper, filed, you pay the filing fee, and the entity, poof, is born, and it exists. Now, there are other documents for each one of these kinds of companies: partnership, joint venture, corporation, and limited liability company. There are other documents, and we call those the constituent documents or the organizational documents of the company. There are some other documents other than just this certificate you file with the Secretary of State. But both in Texas and in Delaware, and actually the vast majority of the states, the entity comes into being upon the filing of that certificate or articles or whatever document it is you're filing with the Secretary of State. Okay? So we form this juridical entity, and now it has a life separate from, and literally an existence, separate from its owners. But you'll all recognize that the juridical entity that is now separate from its owners is like a baby laying there. It can't do anything by itself. It has to have warm-bodied folk that do something on its behalf or as its agents or its officers or its members, and we'll get into talking about those characteristics in a second across the different entities, what they're called. Somebody has to act on behalf of that entity, and those parties may have responsibilities. In fact, generally under the law, they have implied what are called duties, implied duties in the law. We'll get into that in a bit and how we deal with that in Delaware versus Texas and some distinctions that will give you a little flavor for how that part of this works. But at the end of the day, somebody's got to be appointed. Somebody's got to be an authorized person just to sign the certificate and file it. And then after that, somebody has to do something for the entity to have a life, to actually engage in something. So we're going to go through authority issues at that point. Who has the authority to do that? What does the statute say for that particular kind of entity? Limited partnership versus limited liability company versus corporation. The statutes are completely different. All three statutes are completely different in every organization, in every jurisdiction. So you've got to look at the statute that applies to that particular kind of entity. Don't assume that what applies to a corporation applies to a limited liability company and its governance, or to a limited partnership and its governance. Never the trice shall meet. They're all different. So we have to pay attention to the detail in each case. All right. So last, limited liability company. So what's a limited liability company? In general, again, a juridical entity like a corporation, other than a corporation or a limited partnership, in which the owners cannot be assessed for the debts of the company beyond the sums they have invested in the company. They still have invested at the time in the company. Okay? So that's another key feature. Remember that even if we can't, and there are ways we can get to the owners of corporations, limited liability companies, and even limited partnerships. It's called veil piercing. We're not even going to go into that today. That's a completely separate subject. But outside of that, if you invest in a limited liability company or a corporation, your money could be lost, right? So in effect, you have liability. It's just that they can't come get you for more than that, right? They can't come through the entity and get out to the owners in a way that expands the owner's contracted liability for contribution of capital. Make sense? That's not true in a general partnership, which is why we don't use those crazy things. Now, there is one nuance before we move on to and start to work our way through the chart here. I wanted to give you one nuance on partnerships for a second, because of, and you know, my continual babble about the joint and several liability of partners in a general partnership raised significant issues in the 70s, 80s, and 90s, especially in law practices. Because as we went through the 70s, 80s, and 90s, multi-state law practices became commonplace. Law firms that became very large during that time frame began to practice outside the original state in which they started. So you got an organization like, anybody LLC or anybody partnership, law partnership. I won't mention any of them, because if I mention one, I probably should mention them all, and there are too many of them to name. There are lots of big law partnerships these days. But the point is, at one point, every one of those law partnerships was probably a partnership of two people. And it grew in a local office and grew and grew and grew. The practice got really significant. They realized that they needed to do some work in Washington, D.C. Their clients got big and they had Washington, D.C. needs. So they go hire some guys in Washington, D.C. Pretty soon they have partners in Washington, D.C. And all of a sudden, some special rules about the practice of law begin to apply. That is, you can't practice law across state lines without a law license in the other state. And all of a sudden, we've got partnerships of partners of lawyers who are licensed in different states, and we really don't know what to do. And then the lawyers in the other office, and the only way we could practice, we couldn't practice in professional corporations. You could only practice in a professional corporation in the state in which you were licensed. Can't create multi-state professional corporations. That was just the law. And it's continued to be the law. So we could only practice in a general partnership across state lines. It was the only way it could be done. But now your joint and several liability problem comes. So if a guy in the partnership commits malpractice in Washington, D.C., it hits every one of us here in Texas, and there isn't anything we can do about it. So all of a sudden, people got real concerned about and began to become inventive in the 90s about how to solve that problem. And ultimately, we ended up with what was called the Limited Liability Partnership Acts, or the Registered Limited Liability Partnership Acts, which allowed partnerships, general partnerships, to file an election, a filing form, a lot of times every year, along with a filing fee, per partner filing fee, like in Texas, per partner filing fee every single year, to become a registered limited liability partnership, which all that did was, it didn't change the fact that this was still a partnership. What it did was made that partnership a partnership in which the joint and several liability of all partners for 100% of the obligations of the partnership, that's what that means, got cut off, so that a partner was only responsible for their share of the partnership obligations, not for everybody else's share too. It was a way for us to cut off joint and several liability by filing a filing fee, still used today by the large law partnerships across the country in every jurisdiction in which they operate. Okay, so limited liability companies, I wanted to mention registered limited liability partnerships or limited liability partnerships. And by the way, I used one of those not in a law partnership setting, but in another partnership setting as an election for a client of mine for a decade while they were in business, in the oil and gas business, in which they were in a partnership where the parties didn't want to change the form of the organization for several reasons. Okay, so we filed limited liability partnership election and maintained it throughout the term of that partnership. Okay, So let's run down through at that, kind of now running back down through basic juridical entities and how they work. Let's just take a run through, what do I have? So we've got about 25 minutes left. Let's just take a run through these peculiar characteristics. And I want you to see something that I've done in this chart. This is not exhaustive. It's pretty, it covers the ground pretty well, let me say it that way. But it's not intended to be exhaustive. There's a whole list of other characteristics or issues that we could be dealing with. But these hit the high points, I think, and it'll give you something to walk away with that you can go back and sort of refer to and ask yourself, okay, what do we really have here, and what would be the best choice of entity if we were going to do one? All right. So what I have are five types, and we've talked about them already, except for one. We've got sole proprietorship in the column on the left. Second column is partnership, and we've got both that GP stands for general partnership, and the LP stands for a limited partnership. And by the way, one aside on limited partnerships: a limited partnership is a partnership which requires two partners, at least two partners, at least one of which has to be a general partner, and one of which has to be a limited partner. Okay? Now beyond that, we can have multiple general partners, we can have multiple limited partners, but we have to have at least one general and at least one limited in a limited partnership. What happens in a limited partnership? In a limited partnership, the limited partners have limited liability, like shareholders of a corporation or limited liability company members. They have limited liability to whatever they contribute in. They can't, a creditor can't come through the entity out to the partners and out to the limited partners and get more money from them, for example, or make them liable. Again, absent the veil piercing stuff I talked about earlier, which we're not going to get into today. But the real important point about limited partnerships is that somebody, that is the general partner, has to be liable for all of the debts and obligations of the partnership in a limited partnership. So at least one party in a limited partnership is liable for everything, the whole thing, lock, stock, and barrel, which, as a practice point, is why we never, and never is a tough word. Lawyers hardly use always and never, but we never create a general partnership in which a natural person, a warm body, is the general partner. Always create an entity that acts as the general partner, so you can stop that joint and several liability inside that general partner entity. Okay? And Carl's got a bit of a scowl on his face. Let me do an aside here without getting into any detail at all. There are some situations in which, for tax purposes, it's important that a natural person ultimately be the party who's responsible as the general partner in a limited partnership, especially in the family limited partnership setting. And in those settings, if we have to do that, we'll talk about this kind of construct in a little while, but we will form a single member limited liability company, still an entity that houses that liability and stops it. But because it's a single member limited liability company for federal tax purposes, it can be disregarded as though it doesn't exist, but solely for federal tax purposes. And that's kind of way outside this discussion. That's much more of a tax discussion. But in some really sort of fancy planning situations, we have some settings where it's important for us to be able to get back to the natural person for tax purposes, but we still want to put a juridical entity in the way and not have the tax consequences stop inside that entity. And the way we do that is we use single member limited liability companies to do that fancy tax sort of thing. Anyway, okay, so characteristics and structures. We've already sort of talked through this first line of sole proprietorship, partnership, GPLP, C corporation, and S corporation and limited liability company. We really haven't given you the distinction between a C corporation and an S corporation, all right? And in view of state law, there is no such thing. A corporation's a corporation's a corporation. There's no such thing as a C corporation versus an S corporation. You go down to file a charter at the Secretary of State of Texas or in the Secretary of State of Delaware's office, there's no such thing. It's just a corporation charter. You're going to file a certificate of incorporation, you're going to file it, and you have a corporation. So what's the distinction? C corporation is referring to subchapter C of the Internal Revenue Code. S corporation is referring to subchapter S of the Internal Revenue Code. So they are both state law corporations formed exactly the same way under state law, but one of them files, the S corporation files a special election to be treated specially so that it is not taxed, so that the S corporation is not taxed for income tax purposes at the entity level. The income that is earned inside of that S corporation, the net taxable income that's earned inside that S corporation, is allocated out or parsed out, shared out to the owners of the S corporation, to the shareholders of the S corporation, and they report the income taxes on their income tax returns. So the S corporation still files a return, but it pays no tax with that return. A C corporation, a standard corporation that has not made an S corporation election, not a qualifying S corporation that can make an S corporation election or has made one, the C corporation will pay corporate level income taxes, and when it distributes money out to its shareholders, all the publicly traded corporations, all C corporations, they have to pay tax at the corporate level, so they file a Form 1120 and they pay an income tax along with that filing, and then the shareholders don't have to pay an income tax on the value of the profits that were made inside the corporation. But if the corporation turns around and distributes money out to the shareholders in a C corporation, then to the extent those shareholders receive money, and again, it depends on whether it's dividend or capital distributions or the like, whether it's in excess of the basis that they have in their stock, they have to declare income that they've received as dividends or as capital return or capital gains. They have to recognize those as dividends and declare them on their personal tax returns and pay tax on it. So you pay two levels of tax in a C corporation, one at the corporation level and one at the shareholder level when you make distributions. And in the S corporation, you don't incur tax at the corporation level, but you have to pay tax at the individual shareholder level, whether the corporation distributes money out to you or not. You have to pay tax on the taxable income that was gained inside the corporation, the S corporation. Okay? So that's the distinction between C Corp, S Corp, and then let's look at number of owners. Obviously, the sole proprietorship's a sole proprietorship. It means one. If we have more than one person in business together, what do we have? Partnership, right? If we have more than one person in business, we flip over into partnership. That's two or more. You can see that in that line. And then in a corporation, I only have to have one shareholder. I can be a sole shareholder of a corporation. Could be a sole shareholder of a limited liability company. As I just said, you can have a single member limited liability company. So now, this S corporation note is an important one. That is 1 to 100. Can't have more than 100 shareholders in an S corporation. That's just one of the requirements under subchapter S. You can't have more than 100. Types of owners. Individuals in a sole proprietorship. Yep, individuals. Partnership can be any parties. So we could have a partnership, as we were talking about joint ventures. We could have a corporate joint venture. Partnership of two corporations in a partnership together, right? Or two LLCs, or an LLC and a limited partnership, or any combination you want. No restriction there. Any will work. Corporation can be owned by any party, Natural persons, trusts, retirement accounts, which are in fact trusts, all kinds of things. Corporations can be owned by any, there's no restriction on corporate ownership. S corporations, this is where it gets funny. LLCs, by the way, can also be owned by any party, doesn't matter, okay? S corporations, because not only are they limited to 100, but S corporations are intended to be limited only to natural persons, warm-blooded bodies that actually own the stock of the S corporation and make the election to ignore the corporation for tax purposes and have all of the corporation's taxable income flow through to, we call it flow through to the individuals that own the stock of the corporation, okay? And I've made some other notes down there about, there's some other exceptions. There's a thing called a QSSS, and I'll just mention it. It's called a qualified S corporation subsidiary. So ordinarily, an S corporation can't be owned by another corporation. It can't be owned by a limited partnership or a partnership, an entity taxable as a partnership, or by another corporation, or some qualifying trusts, very limited, but it can't be owned by, not even one share can be owned by any of those kinds of parties. And so, but there are some special exceptions to that, some of them being certain kinds of trusts, and an S corporation is allowed to be owned by another S corporation, another qualifying S corporation. So you'd have an S corporation on the top with all qualifying owners under 100, and then underneath that S corporation could drop a subsidiary down that itself could elect to be treated as a qualified S corporation subsidiary, what we call a QSSS, and all its income would be deemed to be earned up inside the upstream subchapter S company. Okay? That's the only way that an S can be owned in that way by another company. All right. Titles of owners. Okay, so let's just go through those quickly, and we'll just go across the top. And I've indicated this down further in the outline, but we'll just skip through those later. And that is, how do we refer to owners in a sole proprietorship? Well, it's the proprietor or the owner, right? How do we refer to partners in a partnership? As partners, or in a joint venture as venturers, right? How do we refer to corporate owners? Shareholders. They own shares. They're shareholders, whether it's C corporation or S corporation. How do we refer to LLC owners? They're called members. They're called members. They're not called shareholders. They're called members, okay? They hold the same position as a corporate shareholder does in a corporation, but they're called members. They're not called shareholders, all right? So you got to sort of get your head around the different titles that get used, and we'll talk about some other titles here in a little bit. Classes of ownership. Well, there is no separate class of ownership. There's only one. It's really not applicable in a proprietorship, right? In a partnership, what do you have? Well, you can have as many classes of partnership interest as you can dream up. You can have all kinds of classes of partnership interest with all kinds of rights. You can do the same thing in a limited liability company. And frankly, you can just about do the same thing in a corporation. Back in the day before we got into limited liability companies, and that really became the rage, back in the early 90s, I was busy drafting preferred stock designations that had all kinds of weird terms in them for corporations, because that's the way it worked. Or drafting all kinds of weird provisions and classes into partnership agreements, including limited partnership agreements, because that's what we had available to us at the time, right? Today, we draft all kinds of wild classes into our partnership agreements, our limited partnership agreements, our limited liability company agreements, right? And our limited partnership agreements. We can do all kinds of things with it. All of those are kind of unlimited in terms of the kinds of classes we can create. The distinction you need to pay attention to on differences in ownership is in S corporations. You can only have what's called one class of stock in an S corporation. There's a technical point here, and that's not really true, and I make the note that you can have a second class of stock, but it has to be pari passu with the voting class. You can have voting and non-voting distinctions in S corporation classes of stock. So you can technically have two classes of stock, but that can be the only difference. You can have no economic rights differences. There can be no contractual or other distinguishing differences between one class of stock and another in an S corporation in terms of economic rights. And the service has been absolutely clear about that. They'll look through your contracts, they'll look through employment agreements, they'll look through all kinds of things to see if you're trying to get around the two class of stock or the one class of stock limitation in an S corporation. So you got to be careful about that one. All right, so classes of ownership. Attributes of the entity, in a sole proprietorship, as I said, the owner's liable for everything. In a general partnership, the owners are jointly and severally liable for everything. Okay? In a limited partnership, the general partner is liable for everything. In corporations, the owners are not liable. In limited partnerships, the limited partners are not liable. In LLCs, the members are not liable for the debts and obligations of the entity. And again, I'll say to you again, I'm making these categorical statements There are exceptions if we pierce the corporate veil. Okay, there are ways in which when bad things happen, when powers or authorities are substantially abused, fraud occurs, or the like, that members or creditors of corporations or limited liability companies may be able to find their way through the limited liability shield of these entities and get to the owners or get to directors, officers, or others on claims. So this isn't categorical. I'm trying to give you the general rules as they apply to the veil protection that comes with LPs, LLCs, and corporations. Okay? So generally, these juridical entities are legal entities recognized as separate from their owners, whereas a general partnership and a proprietorship are not considered separate entities, generally separate from their owners. They're considered an aggregation of persons rather than a separate entity that stands alone. I've got, we have advantages, some statement of just kind of major advantages and disadvantages. Generally, so for example, with a general partnership, there's no filing fees. You don't file with the state. Limited partnership, all the juridical entities, there's a filing fee. There's organizational documents that need to be created. At the very least, a certificate of formation or limited partnership that has to be created to be filed. Whether you use an oral partnership agreement or an oral limited liability company agreement or not, can be up to the parties. I wouldn't recommend it. In fact, I'd highly recommend very well drafted constituent organizational documents in each of these entities. Disadvantages, we've talked about liability already. One of the disadvantages of both proprietorships and general partnerships is that the owners of those entities are subject to self-employment tax. Another thing to recognize, and this is a really advanced tax concept, but partners in partnerships that are taxed as partnerships, by the way, limited liability companies, even though they're not partnerships as a matter of statutory law, they are ordinarily, if they have more than one member, are usually taxed as partnerships under subchapter K of the Internal Revenue Code. Partners of partnerships, as seen through the eyes of the code, the Internal Revenue Code, cannot be employees of the partnership. Cannot be employees of the partnership. They have to be partners for purposes of their profit, loss, and gain from the partnership. Now, they may get a salary or draw, but it's not on W-2 like people who get paychecks get a W-2. It's on it's on a different form. It's actually on their K-1 for the partnership, and it's under a line called guaranteed payments that they receive. So anytime a partner receives a, quote, salary, it's not W-2 income under the code, it's a guaranteed payment, and there's a special definition for that, and I've gone way too far into the weeds for you at this level. Okay, sorry about that. Transferability of ownership interests, important. How do we get to transfer of interest in these settings? Actually, no restrictions on any of these transferability of ownership other than that at the partnership level, whether it's general partnership, limited partnership, or generally limited liability companies, because they're usually privately held. They're usually closely held among 2, 3, 4, 10 people who know each other. There's generally provisions that prohibit the assignment or transfer of those ownership interests without somebody approving it, whether it's the board of managers or the owners themselves as a group or the like. There's usually transfer restrictions on ownership. There are some, by the way, as an aside, and I didn't put a note in here on this, there are some transfer restrictions that you need to be careful about under federal securities laws to make sure that you're complying with federal securities laws as you go on, especially in private entities. Typically, good constituent documents in an organization will deal with that issue, address it, and make sure that whatever compliance is required is completed. So transferability. Otherwise, corporations, freely transferable. Doesn't matter whether it's a C corporation or generally an S corporation, although remember, S corporations can only be owned by certain kinds of owners, and therefore transferability is restricted in that way to particular classes of owners. And by the way, when you transfer ownership interests, you're going to potentially have tax consequences. There are going to be gain or loss on those transfers. It depends on whether they're gifts, whether they're contributions to capital to another entity. There's a whole lot of ways that you can defer taxes on the transfer of ownership interests, whether they're corporate shares or LLC interests or limited partnership interests or the like, or proprietorship interests when you go to incorporate a proprietorship. Let me see what I've got left. 6 minutes. So let's run down through it. Operations and management, obviously self-manage. I wanted to point out that the three others, that corporate governance generally has pretty strict kind of operations and management structure that the corporate statutes have long held. Corporations are governed by boards of directors. Could be one person on the board, but they're governed by boards of directors. The board of directors may appoint officers, and it usually does, president, vice president, secretary, treasurer, and the like, standard corporate offices. And those parties then carry out day-to-day affairs, day-to-day business. But the board of directors is really in charge of governing the entire conduct of the business of the corporation. The same thing can be true in a limited liability company, but it doesn't have to be. We can have the members be the managers, the owners themselves can be the managers, and or manage the entity as though they were partners in a partnership. They can manage it directly. Partners in a partnership manage directly, unless they appoint a managing partner, which is, requires a document to be written and those sorts of things. All right. So ordinarily, board of directors and then officers carry out day-to-day affairs. In a limited liability company, managers, if it's a manager-ruled LLC, unless they've elected, and we don't, in our practice, we don't ever elect to have management by members. We want members to be separated from management. We want managers to manage. So we usually appoint a single manager, usually one of our entities, one of our management entities, to be the manager of our LLCs. Not unusual. We set up special purpose manager entities, in fact, for most of our projects. So LLC provides a lot of flexibility, as do partnership. But a lot of these notes, you'll see fairly similar notes on flexibility between partnerships, limited partnerships, and limited liability companies, where you may see less flexibility or some inflexibility in corporations, the way corporations work. Officers are permitted in partnerships, corporations, and limited liability companies. You can name them if you want. You have to name them in corporations. You don't have to name them in partnerships or limited liability companies. We do in our practice. Can we eliminate, this is one of the important points, can we eliminate or waive common law duties, fiduciary duties, and the like in these entities? The answer to that is, under current law, depending upon, and I can't give you a survey of state law across the 50 states, but we'll use Texas and Delaware as examples. In Texas, we have limited rights to waive corporate fiduciary duties or fiduciary duties that apply in partnerships, limited partnerships, and limited liability companies. We have limited ability to do that, but we can waive or limit some of those duties. In Delaware, we can completely eliminate and waive all duties, all fiduciary duties of managers and officers and members of a Delaware limited liability company and Delaware limited partnerships. We can waive all of them. Got to write a really good operating agreement or partnership agreement to get it done and make it stand. But that can be waived entirely. It's what we do in all of our governing documents. We waive all fiduciary duties. The set of duties you can't waive under Delaware law is the duty of good faith and fair dealing. That's beyond the scope of our discussion today, but it is not fiduciary in nature. And so the duties of loyalty, the duties of care, those can be waived in the state of Delaware. And the trustee level duty that generally applies at the fiduciary, as a fiduciary level, can be waived in Delaware. And we have express waiver provisions in all of our operating documents to accomplish that. I'll let you read on employee incentive plans, liability and reporting, fiscal year, deductibility of losses. Let me just talk as I close. Let me just talk quickly about and just make a note of state taxes. So how are these different entities or organizational formats or forms taxed at the state level, not at the federal level, but at the state level? It depends. Hate to be a lawyer. Sorry for the answer. It depends. Depends on the state law. Each state law is different. So, for example, here in Texas, we don't have a personal income tax, as you all know. We don't have a personal income tax in the state of Texas. We don't have a corporate income tax in the state of Texas either. We have what's called a margin tax. And that margin tax, as a result of a number of iterations since its implementation in the 90s, has now sort of devolved into, in effect, a business entity tax, a tax on all business entities in the state of Texas. It doesn't matter whether it's in the form of a partnership or a limited liability company or a limited partnership or a corporation. Doesn't matter. Or an S corporation. Doesn't matter. All business entities have to file a return with the comptroller, the Texas comptroller, and report their revenue to the comptroller. There are exemptions that don't require the filing of a tax, but you still have to file a return. It may be what's called a no tax due return, but you still have to file a return. The return may be a total of 8 lines long and say, 000, or the net, the gross income is under the threshold, which, Ron, do you recall these days? The threshold on margin tax is about $1.1 million or $1.2 million or so in gross revenues right now. So there's always been a small business exemption where you don't begin to incur a tax if your business is small enough to be under that category, but you still file a no tax due return, you report your revenues, and you show them that it's under the threshold, and then away you go, right? And in Delaware, what do we file in Delaware? Well, Delaware has an income tax. Corporate, limited liability company, limited partnership. So we file all of our charters in Delaware. Virtually all of them. There's a few in Texas, but virtually all of them in Delaware. So does that mean we pay income taxes in Delaware on all the money we're making in all these states? No, because the Delaware corporate income tax and the Delaware individual income tax, they recognize flow-through entities like partnerships and LLCs taxed as partnerships. So there's no imposition of income tax by the state of Delaware on non-resident owners or on income that's generated outside of the jurisdiction of Delaware. So unless we have an operating property like a multifamily property or hotel operating in the state of Delaware, no income tax is due under the income tax in Delaware. But we still have to file every year by June 1 a filing and a renewal filing for every one of our LLCs and every one of our Delaware limited partnerships, and file. It's a $300 fee and a filing. You do it every single year, and we've got hundreds of entities that we pay $300 every year when we file, because we have to file them to keep the charters live in Delaware. Okay? So that's how the tax works there. We file a report, but we don't have to tell them how much money we're making. We're not subject to their income tax. We just have to file what is in effect a flat tax. Okay? All right. So I've covered a lot of ground. As I said to somebody earlier, I could probably stand up here and talk about this stuff for about 6 hours without an outline.